I just did a major video explaining why the anti-gunners are hot and heavy into trying to argue that the relevant time period for measuring the scope of the Second Amendment is not 1791, when the Second Amendment was actually adopted by our founding fathers at the time of the Bill of Rights, but instead the anti-gunners want to talk about the late 19th century, starting with 1868, on the grounds that the 14th Amendment, which applied to states and localities, is the key time period to show historical analogs to modern-day gun control laws. Why? Because the anti-gunners think there's a lot more gun control laws in the late 19th century, in part because of the black codes that basically look to discriminate against African Americans, the freed slaves, when it came to exercising their right to keep and bear arms, among other things. But the anti-gunners are laser focused on the late 19th century, and I want to give you 3 quick reasons why this is clearly wrong so you can understand it as well. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, best-selling author, constitutional attorney, and member of the United States Supreme Court Bar. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. Okay, folks, we know that the anti-gunners are laser focused on trying to get courts to wrongly look for historical analogs of gun control laws in the late 19th century after the adoption of the 14th Amendment, which came on the heels of the American Civil War. And why are the anti-gunners hot and heavy to look at the late 19th century? It's because there were some gun control laws in the same way that there were no gun control laws to speak of in 1791. So the anti-gunners are trying to get America's courts, in my opinion, to dupe America's courts into embracing an interpretation of the scope of the Second Amendment that is clearly wrong historically and wrong according to the Supreme Court precedent. Now, I have a scholarly paper that I'm putting a link to down below for you lawyers and judges and law clerks out there, or anybody who wants to look at this kind of scholarly work. Check it out. It goes into great detail. But all I want to do in this video here is give you 3 quick reasons why 1791 is the proper time to look not only at the scope of the meaning of the Second Amendment, but also to make sure that if you're looking for historical analogs to understand what was acceptable gun control law, if any, you have to look at relevant gun control laws, if any, in 1791. And you're simply not allowed under Supreme Court precedent to look to the late 19th century. And if you do so, you're making an error legally and historically if you go there. Let's begin. The Second Amendment was adopted in 1791 along with the rest of the Bill of Rights. To understand the original public meaning or the public understanding of the Second Amendment, you have to look at the time it was written and adopted, right? And when was that? Well, the Second Amendment was written and adopted and ratified in 1791 along with the other Bill of Rights. So therefore, you have to look at 1791 to understand what people thought they were protecting from a rapacious or tyrannical or unduly growing or onerous government. So you had to look at what they were trying to protect. You have to understand what was going on in 1791. Relatedly, if you want to talk about any acceptable historical gun control laws, if any, you also have to look at 1791 to see what the founding fathers thought were appropriate, if there were any appropriate gun control laws, and then ask yourself, are those gun control laws in 1791 somehow analogous, sufficiently similar to what like New York passed or California is passing? And if the answer is no, they're not, they're dissimilar, they're not similarly situated in any respect, well, then the modern-day gun control laws, according to the U.S. Supreme Court, get tossed out. They're not allowed to exist. So beyond that, I think there's 3 critical reasons why 1791 is key. First one is you can only have one meaning, one understanding of the Second Amendment that applies all across America. You cannot have 2 separate Second Amendments. What do I mean by this? If you buy into the anti-gunners argument that the way to understand whether or not the Second Amendment restricts the ability of states like New York, New Jersey, California to restrict gun rights, well, you have to look at historical analog gun control laws in the late 19th century. Why? Because that's when the 14th Amendment was adopted in 1868. But that makes no sense, and why is that? Because what the anti-gunners' position would essentially be arguing for is that the Second Amendment has a particular meaning as restricting the powers of the federal government. Because remember, in 1791, the purpose of the original Bill of Rights was to restrict the powers of the new federal government. It wasn't specifically designed to restrict the powers of the state or local governments in America. So if you buy into the anti-gunner argument, they're basically saying that in 1791, the Second Amendment had one meaning as applied against the federal government, but then the Second Amendment somehow morphs and somehow has some different understanding or meaning or scope of protections based upon the understanding of what it meant in 1868 and whether or not there are historical gun control laws in 1868 or thereafter. But that's not how the Constitution works. You have a single First Amendment that applies across the board. It's understood across the board, whether it be applied to the federal government, or the states, or whatever. Same with the Second Amendment. It has to be understood across the board in the country, regardless of which government entity may or may not be violating that right. You can't have two separate Second Amendments. You can't have two separate First Amendments. That's not how the Constitution works, but that's what the anti-gunners are really arguing for, and that's why they say, well, yeah, we understand in 1791 the Second Amendment had one meaning, but it really has a much more narrow, restrictive meaning when you apply it to the state and local governments because of the 1868 14th Amendment and the analogous gun control laws then. Obviously, that's nonsense. The Supreme Court has never said that, which leads me to my second point here, that if you look at the Supreme Court cases interpreting the rest of the Bill of Rights, including the Second Amendment, they all look specifically to the historical understandings in 1791 or at the time of the American founding, because that was the period in which the Bill of Rights was written. So you have to look to understand what the Bill of Rights meant then, because that's when it was written and ratified. The only purpose of looking to 1868 for understanding what the Bill of Rights meant in 1791 is confirmatory in nature. I want to make clear what it means, why 1868 is only relevant to confirm the original understanding of the Second Amendment in 1791. The understanding of the Second Amendment, or any aspect of the Bill of Rights in 1868, cannot, I repeat, cannot contradict or restrict the scope of the protections of the Second Amendment as it was understood in 1791. So what does this mean? Well, Judge Brett Kavanaugh, before he was on the United States Supreme Court, was on the D.C. Court of Appeals, which is the D.C. Court one step below the U.S. Supreme Court. Judge Kavanaugh wrote a dissent involving a so-called assault weapon ban in the District of Columbia. The name of that case was Heller 2. It was the second case that came after Heller 1 that went to the Supreme Court and the Second Amendment Community 1. Heller 2 dealt with an assault weapon ban, and Brett Kavanaugh wrote that the assault weapon ban was unconstitutional under Heller. And what Brett Kavanaugh explained was that you look to the Second Amendment when it was written in 1791 to understand the scope and its protections. You are allowed to look to 1868 in the late 19th century, but you can only look to those understands in history to the extent that history is consistent with and affirms or confirms the meaning of the Second Amendment in 1791. If there is historical precedent in the late 19th century that contradicts or violates or is inconsistent with the understanding of the Second Amendment in 1791, you do not consider it. You do not consider that history. It is verboten. It is not allowed. That is not me. That is what Judge Brett Kavanaugh said in the D.C. Court of Appeals and what the Supreme Court basically said in their multiple Second Amendment cases. That the only reason why the 19th century might be relevant is to confirm the meaning of the Second Amendment in 1791. Now, I should note the reason why this sort of can of worms got opened and why the anti-gunners are going there is because the Supreme Court had some language in NYSERPA versus Bruin where they said, look, we just want to be clear. Whether you apply the Second Amendment with an understanding and the historical analogs of gun control laws in the 18th century, 1791, or whether you look to gun control laws involving the carrying of guns in the late 19th century, it doesn't matter. We don't need to decide it in this case because the history in both time periods shows that the right to bear arms means the right to carry. Again, don't forget, the right to keep arms means the right to possess, to have, to own. The right to bear arms means the right to carry them. And the Supreme Court says we don't need to get into this historical debate right now because no matter which time period we look at, the pro-gun rights groups win because the Second Amendment protects the right to carry guns. We totally agree no matter which part of American history you look at. And that's why the anti-gunners are saying, see, the court didn't decide it. We should be looking to the late 19th century. But the Supreme Court's made it clear in other cases, including NYSERPA versus Bruin, that really the right answer is 1791, but they're willing to leave open the door conceptually, scholarly, possibly that under certain circumstances, maybe they look at the 19th century, but overall, that's really not what they're doing. The last point I want to make about why 1791 trumps 1868 is the 13th, 14th, and 15th Amendment. What was their purpose? Well, they were all adopted and ratified after the American South lost the Civil War, which we fought over slavery. And the 13th, 14th, and 15th Amendment were all designed to make sure that the freed African American slaves had the same rights, the same legal rights, the same constitutional rights and protections as other Americans. Remember, the 13th Amendment outlawed slavery. The 14th Amendment said that the former slaves had the same rights and had equal protection of law as did the other Americans, right? That's what the 14th Amendment was about. The 15th Amendment said that the freed African American slaves had the right to vote. So what was the purpose of the 13th, 14th, and 15th Amendments? The answer was the whole purpose of these was not to change the understanding or the meaning of the Bill of Rights. It had nothing to do with changing the scope or understanding the meaning or anything about the Bill of Rights. What it had to do with was making sure that the protections associated with our fundamental American values and rights, such as the Bill of Rights, were guaranteed to those freed African American slaves, so they had the same rights, including the right to keep and bear arms, as the rest of Americans, as the other American citizens. So it had nothing to do with changing the meanings of the Second Amendment or any of the other aspects of the Bill of Rights. It had everything to do with allowing a new group of Americans, the freed slaves, to have access to and have those same rights protected as the rest of Americans did, not just against an oppressive federal government potentially, but also against oppressive state governments and local governments and city governments and village governments. That was the idea behind the 13th, 14th, and 15th Amendments. So to summarize, the anti-gunners want to argue the late 19th century, we must stop them. We must not buy into this. We must not allow courts to be duped. We must not allow anyone to be duped. The relevant time period for both understand the scope of the Second Amendment and for when a court or other public policymaker can adopt a historical analog, right? To look for a historical analog to justify a modern day gun control law, they must look to the relevant time period, to the relevant history, which is 1791, the American founding, to find the historical gun control analogs, if any, to compare them to show that a modern day analog exists and is justified. Do not let the anti-gunners, do not allow courts to make the mistake of looking to the late 19th century to say there were gun control laws in the late 19th century, therefore New York or California or New Jersey can uphold these various gun control laws today based on late 19th century American law. That is not the time period to look for historical analogs associated with the interpretation of the Second Amendment, which is ratified and adopted in 1791. Okay, hope you learned a little bit something here today. I'm sorry I'm belaboring this point, but it's mission critical for the movement, so that's why I'm doing it. If you haven't subscribed, please do so, and we'll see you again soon at the Four Boxes Diner.
Orders up. Table 2A.